Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have received so much feedback, comments, and also questions concerning what we've called Dateline-Gate. In other words, the fact that sensitive information not previously publicly circulated was reported during a recent Dateline TV program related to this case and the defendant Brian Kohberger, which Judge Hippler found that it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated the court's non-dissemination order. Violation of a court order is called contempt of court. People go to jail for contempt of court, and Judge Hippler has addressed the very high level, the damage that has potentially been caused here, when he addresses the fact that such violations not only undermine the rule of law, potentially by persons charged with upholding it, undermining the entire judicial process, the entire legal process, and then prospectively by people who are out there enforcing the law as to other people. He also points out that it significantly impedes the ability to seat an impartial jury. That is a federally constitutional guarantee that Mr. Kohberger has, a right to an impartial jury under the 14th Amendment of the Due Process Clause. This is to the U.S. Constitution, and it says that when the government is seeking to take someone's life, liberty, or property, they must first receive due process of law. And at the heart of due process is impartiality. If there is not impartiality, there is no due process. He talks about the other problems, the increased cost to taxpayers, the possible inconvenience to jurors who may need to be sequestered, and so on. And then we see the magic words here. The court finds it is imperative, crucial, in other words, ladies and gentlemen, to attempt to see that the source of the leak is identified. So he wants the person found, and not just found, but held to account. Those words tell us that it appears he intends to sanction this person who's ever responsible. Not only because that person needs to be dealt with, but also because he finds it will be the best deterrent to future violations. This court order required both sides to turn over information to the court within 7 days, and if they fail to abide by anything contained in this order, failure to comply may be a basis for the finding of contempt of court. Violation of court order, as we've said, is contempt of court, and people go to jail for contempt of court. Ladies and gentlemen, could evidence be thrown out? Evidence is thrown out as a sanction for bad faith behavior. Will it happen in this case? We don't know. What type of evidence might be thrown out if the court decides that that's the appropriate sanction? Well, we have to look at the second to the last paragraph above Judge Hippler's signature line, page 2. First off, he wants the list of all individuals within law enforcement and the prosecuting agencies, past or present, who are known to have had access to, number 1, any facts related to the investigation of the defendant. Number 2, including but not limited to surveillance videos of suspect vehicle 1. Number 3, the AT&T records for defendant's cell phone. Number 4, the content of defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with defendant's Amazon account. And in the event that Judge Hippler somehow overlooked something, there's a catch-all. Or any other information referenced in the above mentioned Dateline episode regarding this case. The 7-day window for both sides to get the information to Judge Hippler for in-camera review, that means his eyes only, in chambers, was this past week. It was 7 days from the 15th of May. So we have to wait and see what happens. As further facts come up on the record, we will report it to you because we know that many people are interested in this. In the interim, if you have any comments or any feedback, please leave it here. Until next time, this is Kathy. Thank you so much for joining us today.